committee. The committee, of course, investigating the events leading up to and around the January 6th insurrection. Now, you'll recall it was back in November that Bannon was indicted on 2 counts of criminal contempt of Congress. Those committee members had wanted to talk to Bannon about what took place regarding the planning, if any, around the events of January 6th. It was a month after the Justice Department received a referral from the House committee. That referral came in October of last year, that indictment then in November followed. Now, each count, as we understand it, carries with it as long as a year behind bars. Right now, we're waiting to get more details from our CBS News staff. We have our producer, CBS News producer Robert Laguerre, inside the courthouse in Washington, D.C., as well as, of course, our Scott MacFarlane, CBS News congressional correspondent, who has been following all of this. But, Christina, this is a case that really so many people have been watching in Washington. They're now a live look outside the federal courthouse there. We are waiting to see if we hear from attorneys, from perhaps even Bannon himself, who we should point out has not been hesitant to talk outside of the courtroom about what has been taking place.
But he didn't testify at this trial, and his attorney said that was because all the motions that they wanted to make, the things they wanted to address, whatever he was going to present as his defense, they weren't allowed to do that because those motions were overruled by the judge. So they said his defense teams said that he wouldn't be allowed to speak the truth. That's their perspective on it. So he didn't speak. And from reporters who were in the room, they said he mostly, looked at his phone. He shuffled around a little bit. He seemed a little bit, implacable. But he has come out and spoken to the stakeout cameras. His attorneys have come out. We've heard from the Department of Justice as well. And this all kind of centers around this missed deadline to respond to this subpoena. His defense has also argued, these dates are flexible, they're not hard dates. And what the people who testified on behalf of the government said is, look, these are not hard dates if you are cooperating. But if you're not cooperating, I think, is this File, or we're seeing him come out now? This is File, I apologize. If you're not cooperating, then that date is not flexible. They're willing to work with you. You don't have to show up if you're in negotiations. But they're saying they didn't hear from him. They didn't hear from his team until after that deadline has passed, at which point they said, he was using executive privilege and he didn't believe he had to testify. Now, he was not an official White House advisor at the time of the January 6th incident. So there's been a lot of debate over whether or not executive privilege would even apply because he wasn't a White House employee.
Right. So let's bring into the conversation our CBS News legal contributor, Keir Dougal, joining us by phone right now. And Keir, I know you've been watching this as well. This was a quick trial. I mean, jury selection began on Monday, and here we are. It's Friday. Perhaps not a surprise that a verdict is coming on a Friday afternoon, as we know tends to happen sometimes. But what's your reaction to the fact that we have this verdict, we have it quickly and guilty on these 2 counts?
Yeah, my reaction is that it's a simple case. The issues are pretty straightforward. You comply with the subpoena or you don't. And I think that's reflected in the speed with which this jury deliberated and returned its verdicts.
It often seems odd in cases where you don't hear from the person who's being put on trial. You don't hear from the defendant. And Steve Bannon never took the stand. His attorneys didn't call any witnesses. Why didn't they fight harder on his behalf?
Well, I think we read that the judge limited some of the defenses that were and some of the issues that were to be presented to the jury. So I think that streamlined the trial. Those may become issues for an appeal. But it's always a sort of a big decision for a defendant whether or not to take the stand in his or her own defense. That often shifts the focus of the jury from the particular facts directly to the credibility of the defendant, him or herself. It's a very big decision, with the government bearing the burden of proof in these cases beyond a reasonable doubt. It's often a safer decision for a defendant to put the government to its proof and not take the stand.
So we understand that Steve Bannon has since reversed his position on testifying, says he's now willing to speak with the January 6th committee. Keir, could that potentially play a role in his sentencing if he follows through and testifies?
So that's a really interesting question. There are sort of a number of different ways that the Congress can get its subpoenas enforced. One way is through civil litigation. We've seen the Congress sue officials, individuals that they're seeking information from. We've seen individuals seek declarations from the court, asking the court to say these subpoenas aren't valid. So that's sort of the civil case, civil avenue. Those things can often lead to negotiations that result in information being given over testimony. In other words, that process is one that is amenable to finally having a defendant, a witness, give information. That's sort of what's behind door number one. Behind door number two is something that hasn't been used for almost 100 years, which is Congress's own contempt power, where they go out and actually arrest a witness and hold them in the congressional hoosegow, and basically hold them until they either decide they're going to give testimony or until the Congress itself expires. That's behind door number two. It's obviously an escalation, a more fraught procedure, but it also can lead to a witness ultimately changing course and giving information and purging themselves of contempt. What we're looking at right now is the option behind door number three, which is a criminal trial. And that path does not typically and won't typically lead to a witness eventually giving information over, because once you've been convicted, there are very few avenues after that. After the process is shifted over to the executive branch, to the Justice Department, and to the criminal process, there just aren't the options to have Mr. Bannon, turn around now after he's been convicted and incentivize him to give information. So this choice to send him for prosecution is one that is obviously is going to have serious consequences for him if he spends time in jail, and it doesn't have those options that lead to information and a change of course down the road.
So why do you think they decided to go ahead with prosecution? If that's the looming threat, you hold over an uncooperative witness. If you're doing carrot and stick, that's the stick to try to get them to testify. And once they're charged, if there's no way to nullify that conviction, what do they do now? And why would he cooperate if he's been convicted on these charges?
Yeah, so, these are difficult choices that you have to make as a prosecutor, as someone who's running an investigation. You have to weigh the cost of potentially not getting Mr. Bannon's information against the incentivizing effects that you create for everybody else who's going to get a subpoena. All of a sudden, the sort of the rope-a-dope strategy that we've seen lots of people use of this Congress is going to expire in January. I can play this out in the courts. If I lose at the trial court level, I'll take an appeal to the intermediate appeals court, and if I get lucky, the Supreme Court will hear me. And by the time that's all done, it'll be years from now, and this Congress will have expired, and maybe I won't ever have to do anything. That strategy is now one that does not look so good if the Congress has shown that it's willing to hold this looming threat of criminal prosecution over not just Mr. Bannon, but over all of the dozens and dozens and dozens of other potential witnesses that may receive subpoenas from the Congress now.
So that was going to be my next question, Keir. What are the implications beyond just this case, beyond the work of this particular committee, the House Select Committee looking into January 6th? It sounds to me like you're saying now any committee here, a congressional committee that is looking to have a witness come before it with a subpoena, this certainly sends a message about complying.
Absolutely. That's correct. So a congressional subpoena it's not just an invitation. It's not like please RSVP and the party begins at 8 o'clock tonight. Mm-hmm. A congressional subpoena has the force of law and the force of compulsion behind it. now, I mean, this law that has made it a crime that Mr. Bannon has now been convicted of. This law has been on the books for a very long time. But to have a present reminder, one that is covered in the press for a individual as high profile as Mr. Bannon, who a lot of people will be paying attention to have this outcome, I believe, will incentivize, it certainly ought to incentivize lawyers for these witnesses to tell their clients, look, you need to take this seriously. The investigations by this committee of Congress and any other committee of Congress that's issuing subpoenas is serious. It's something that's in the national interest, and it's something that you have a duty to respond to appropriately under penalty of conviction and time in jail. I think the calculation that the Congress made with Mr. Bannon's referral to the Justice Department here was, okay, we may lose his individual testimony. There are a lot of witnesses here. Hopefully we can get the information from somewhere else. Meantime, we need to let people know that we mean business about getting to the bottom of January 6th.
And how rare is it for the Department of Justice to not only bring someone up on contempt of Congress charges, but to go all the way through a trial and, in this case, an eventual conviction? Because I've been covering Washington for a long time, and I will admit this is not my beat, but frankly, I can't remember another case this high profile going all the way through to a conclusion like this.
Right. It's not particularly commonplace. This is a somewhat of a rarity if you think about it in terms of sort of the modern era and current events. If you look back, farther back in time to the post-Civil War era and to the early 1900s era, the Depression era, the trust-busting era, if you look back farther in time, Congress exercising its own inherent contempt authority was much more commonplace. Convictions, if you look back across a longer period, it will appear that, oh, this is not such a rarity. But in the modern era, you're correct. This particular conviction of Mr. Bannon coming at the moment that it does, I think it should incentivize other witnesses to be more responsive to Congress.
All right, Keir, if you'll stay with us for a moment, let's bring into this conversation CBS News senior investigative correspondent Catherine Herridge joining us now with more. And Catherine, for our viewers just joining us, remind us of who Steve Bannon is, his stance, his position within that Trump inner circle, and why it was that the January 6th House Select Committee wanted to speak to him in the first place.
Well, Lane, Steve Bannon is really sort of the ultimate insider when you talk about those closest to former President Donald Trump, not only when he was in the White House, but he remains close to him based on our reporting, even to this day. And he's seen by people in the Trump administration as being sort of a super thinker when it comes to political strategy, someone who has a very good sense of what the Trump voters are looking for in the direction to take. The reason the January 6th committee wanted to talk to him is they wanted to get documents and a deposition about what he knew in the lead up to January 6th. I mean, if you've been watching any of the hearings, especially in prime time, you see that Bannon is a figure that seems to be floating in and out of these discussions leading up to January 6th. So, your final question, how did we get to this point? The January 6th committee sought depositions and documents, and there were some members of the Trump administration, like the White House Chief of Staff, Mark Meadows, who took kind of a hybrid approach. He provided some records, text messages, but he did not sit for a deposition. And the Justice Department weighed bringing contempt of Congress charges against him, but ultimately did not bring any charges against him on that front because he kind of cooperated, even though he didn't provide a lot of cooperation. The error it seems that Steve Bannon made is that he took this all-or-nothing approach, and that's what got him this conviction by the jury, that he didn't sit for the deposition, he didn't provide records, he argued before the court that he thought the deadlines were flexible, and that was simply an argument that the prosecutors rejected, and it was also rejected ultimately by the jury.
Now, can you talk us through this argument that he made that he qualified as having executive privilege, even though he wasn't an official employee of the White House at the time? And where does that stand now? Does that just, because I remember a week or two ago, there were these rumblings that he might actually be cooperating with the committee. Now that he's been convicted, is that completely out the window?
I don't want to speculate. I don't know where that stands, and I don't think any of us really know where that stands except for Bannon and the committee. But like many others, he tried to argue that some of his conversations with the president were subject to executive privilege, but it was a very thin argument because he was not, in fact, part of the administration as an official advisor to then President Trump. I think that there are a lot of possibilities that are now open to him because he's looking at the 2 counts, the conviction, and likely also a fine. He's got several months now until the sentencing in October, so that gives him some time to negotiate a little bit. But really the window to negotiate with the Justice Department is kind of over unless they decide to bring charges against other individuals in President Trump's inner circle or even President Trump himself, because that's where Bannon could provide additional information. But really, there's really been no indication from these press conferences that he's held outside that courthouse that he's really of a mind to cooperate with this administration and this Justice Department.
I don't know if we have Keir Dougal still on the line, but Keir, if you're with us, I'm wondering, with respect to avenues of appeal now, what do you see from your perspective legally as potential avenues of appeal here for Steve Bannon and his lawyers?
So the first one is going to be a challenge as to whether or not the evidence was sufficient. That's a standard challenge. I doubt that will be sufficient here because the facts are pretty straightforward. You got the subpoena, you didn't show up. I think that is something that may not result in too much help for him. But the reporting indicates that the judge declined to allow certain issues to be raised during the trial and certain areas of defense to be raised during the trial. And those, I think, might be fertile ground for an appeal. We'll have to see how those issues are raised and whether or not they appear to have any merit. But those, I think, are the areas that I would expect him to challenge.
All right, let's bring in CBS News congressional correspondent Scott McFarland. He is on the phone with us right now. You are outside the courthouse. Scott, what can you tell us?
Well, first of all, let me be honest. It's 100 degrees. I'm standing inside the courthouse as we wait for Steve Bannon to show up and take a position near the microphones and cameras. He's done that every day. No reason to believe that won't be the case in the next few minutes. This was such quick work for the jury. It took them less than 3 hours, and that's not counting the lunch break they got. The case was short, though, too. Bannon didn't testify, didn't present any evidence, didn't present any exhibits, didn't present any case, just a closing argument. In fact, the jury never got to their seats yesterday because the lawyers are doing all their work just with the judge arguing over motions. So this was quick work in front of the jury, then quick work by the jury. This is obviously a much different case than the January 6th prosecutions, but I'll note the Justice Department is batting 1,000 now in January 6 cases before trials here in D.C., and now in the first contempt of Congress trial before a jury in D.C.
And Scott, what were those arguments among the lawyers? What is it that his defense wanted to bring up that they were overruled and not allowed to address? Do we know what kind of tactic, what kind of approach they wanted to do?
Yes, and by the way, they're setting the stage for an appeal. And they were unequivocal about that in the courthouse. They're going to appeal this and move this to the D.C. Circuit Court of Appeals. The dispute was over whether Bannon could call all the members of the January 6th committee as witnesses, and the U.S. House Speaker, Nancy Pelosi, as a witness. The judge didn't let that happen, says it wasn't germane or relevant. I'll tell you what, I'm seeing some movement here. I think Steve Bannon's coming out of the courthouse, so I'm going to move too. Stand by. I'll have an update for you in a moment.
All right, we're waiting on Steve Bannon, who has been found guilty on contempt charges. That's our reporter Scott McFarland outside the federal courthouse. Now, we want to take a break and take you away from this. We're going to go to the White House, where President Biden is meeting virtually with his economic team to discuss gas prices. Let's listen in.
Good. We've got members of your economic and energy team here, and we're prepared to start the briefing, but we'll start by turning the floor over to you, sir.
Well, thanks. Let me start by apologizing for my voice. I'm feeling much better than I sound. You know, we're meeting today on gas prices, and we have some really good news. Gas prices are coming down. In fact, gas prices have fallen every day this summer for 38 days in a row. Now, you know, you can find gas for $3.99 or less in more than 30,000 gas stations in more than 35 states. In some cities, it's down almost $1 from last month. We've been working really hard to bring the price down. 4 months ago, I gave an order to release 1 million barrels of oil per day, a day, for our nation, from our nation's strategic petroleum reserve. And I led the world to coordinate the largest release of oil reserves in history, including from other countries. In total, more than 240 million barrels to boost global supply. During that time, I've also been working to increase U.S. production. Today, we're producing 12 million barrels per day, and we're on track to hit near record highs. I've been working to make sure that when the price of oil comes down, the price at the pump comes down as well, and comes down in real time. The good news is that's happening, but it's not happening fast enough. We've made progress, but prices are still too high. And so here's what I'm going to do, talk about today with all of you. We need to work on this. First, we're going to look at ways to increase oil production from the existing wells and permits that exist today. The industry has more approved permits for production on federal lands than they can possibly use. That's a fact. Let me say it again. They have more than they can use. So my message to these companies is use the permits or lose them. Don't say we can't, you don't have access. Second, I'm telling the industry, you're making record profits due to Putin's war in Ukraine. Use those profits to increase production and refining. Don't use those profits to buy back your stocks and dividends. Look, thirdly, we'll talk about a global price cap on Russian oil that I got our partners to agree to last month at the G7. That'll keep supply up and Putin's revenues down. In the days and weeks ahead, I'm going to keep doing what I can to bring down the price of gas at the pump. But the real answer is to get to a clean energy economy as soon as possible. Turn this into something positive. That means cleaner renewable energy, more affordable electric vehicles, and clean energy manufactured here in the United States. That's how we'll protect the climate and create jobs. I have more to say about this in our discussions, and more in the coming days. But look, I want to stop here and turn it over to you, Brian, and let's get this briefing started. Thanks.
Great. Thank you, Mr. President. So we're hoping today to cover three broad areas. The first is market development.
We've been watching President Joe Biden meet virtually with his economic team. He addressed the decline in gas prices, but the continued work that needs to be done to help drivers.
Of course, we're covering the president, this now his second day working in isolation after that diagnosis of COVID. We want to take you, though, right now back to the courthouse, the federal courthouse, where Steve Bannon is speaking following a jury finding him guilty of contempt of Congress. This is moments ago. Let's listen in.
We respect their decision today. I really want to thank those hardworking citizens of Washington, D.C. that had to take an entire week off to go through this, so their thanks. We respect their decision. We may have lost a battle here today, but we're not going to lose this war, okay? David Schroen's going to talk here in a second about exactly what the jury heard. They came to their conclusion, right, about what was put on in that courtroom. David Schroen's going to talk to you about our appeals process. But listen, in the closing argument, the prosecutor missed one very important phrase, right? I stand with Trump and the Constitution, and I will never back off that, ever.
This didn't seem like the misdemeanor from hell, Mr. Bannon. What happened?
I thought it was pretty good hell.
This is round one. That's what happened. This is a bulletproof appeal. Have you ever in another case seen a judge 6 times say in the case that he thinks the standard for willfulness is wrong? He said it doesn't comport with modern jurisprudence. He said it doesn't comport with the standard, the traditional definition. But he said he feels his hands were bound by a 1961 decision. You will see this case reversed on appeal. You will see all of these resources, 3 federal prosecutors, 4 FBI agents for misdemeanor, are being wasted. You cannot find another crime in which misdemeanor or felony in which a person is convicted without believing or knowing or having reason to believe he or she did anything wrong. That's the standard that was applied in this case. The government said from the start the standard they were urging on the court was Bannon subpoenaed and did Bannon show up? Doesn't matter his reasons. They won the case, maybe in closing today. They lost their appeal in closing today. The overreaching by the government in this case has been extraordinary on every level. But shame on this office of the United States Attorney's Office and the Department of Justice for how far it went in this case. They put forward an argument today that completely tears asunder constitutional principle of separation of powers. They argued to the jury today that when a person gets a subpoena and executive privilege is invoked, it's for Congress to decide whether the executive privilege is valid and how broad it is. That's absolutely false. The courts, if there's a question whether the question is justiciable in court, but if it is, only the courts can be the arbiter. They likened today Congress to a referee on a playground field with children, and that Mr. Bannon didn't want to listen to the referee. That's not how our constitutional structure works. Whether one believes executive privilege was properly invoked here, was valid, how broad it was, etc., when a former president or a current president invokes executive privilege, it's presumptively valid, period. It's not for Congress to decide that it's not valid. Secondly, from the willfulness standard that the judge felt compelled to apply in this case, and which he said he's inclined to think is wrong, again, all they had to prove was that he didn't show up. That can't be the standard in a case, especially in a case that holds the potential for a jail sentence. So think about it. Any citizen gets a subpoena from Congress, hires an experienced lawyer. The lawyer tells that citizen, you may not comply. Not we ought to think about it. Former president invoked executive privilege. You may not comply. Again, you can debate whether he could have complied in part or in full. He listened to his lawyer. It's not an intuitive process. His lawyer directed him, he may not apply. The Justice Department decisions, as we've said in the past, their official position has been in the past that former and current executive branch employees, when they're served with a subpoena and executive privilege is invoked, cannot be compelled to appear, and in any event that this statute cannot be applied against them. There are issues for appeal in this case that are astounding.
You argue the state.
By the way, the only hang on. I want to thank the jury for the effort they did, the judge, particularly the court administration here, everybody. I only have one disappointment, and that is the gutless members of that show trial committee. The J6 committee didn't have the guts to come down here and testify in open court. Thank you very much.
Does this embolden them? Mr. Bannon, does this embolden the committee?
All right, Steve Bannon there, along with his lawyer, David Schoen, outside the federal courthouse in Washington just moments ago, vowing to appeal. We heard the attorney there say, quote, bulletproof appeal. You will see this case, he said, reversed on appeal. Let's bring in former federal prosecutor Joseph Marino joining us now. And Joseph, your assessment of what you just heard right now from the attorney there for Steve Bannon, talking about the grounds he believes for appeal that he thinks he'll be successful on, notably that when a former president, he said, asserts executive privilege, he said it's not for Congress to decide, it's presumptively valid. He also talked about this notion that a client listening to his lawyer and the directions of that lawyer about not complying, he essentially was making that argument that he should not have been found guilty based on that action, that he was just following the direction of his attorney. What do you make of those arguments?
Well, I mean, hey, look, I understand that you want to put on a brave face and be bullish when you're in a situation like this. I've been a defense lawyer before. I understand how the game is played. The reality is not nearly as strong an argument as Steve Bannon and his lawyer are making it out to be. Okay, he did try to assert executive privilege. It was shot down months ago. It was vetted, and it fails for a number of reasons. One, Steve Bannon was not a member of the White House staff when the events at issue took place. Two, the current president rejected the former president's assertion of executive privilege. And so you can't have that standard apply if the current occupant of the White House says, no, that's not privileged. The other thing is, too, Steve Bannon could have shown up and then selectively asserted executive privilege on the advice of counsel.
Which is what we saw from other people, exactly, from other people who did testify with the committee.
Exactly. Pat Cipollone. We saw videotapes of him in last night's hearing, sitting next to his lawyer saying, okay, I can answer that. This is getting a little close to privilege. Sorry, I got to be careful. And so those kinds of give and takes are what avoid a charge and then a conviction of contempt of Congress. When you say, you know what, I'm not even showing up, I'm not going to give you a single document, I'm not going to participate in any way whatsoever, well, big surprise, you're going to get charged and now convicted.
And what is your take on their interpretation of the parameters of this statute, right? This willfulness, saying that he didn't know he was disobeying the law and therefore he shouldn't be found guilty. Is that the threshold for contempt? Usually you have to be willfully in, disobedience of the subpoena. Does that play in normally, or is that something they're trying to pinpoint for this specific case?
I think it's a clever argument, but I think you can raise it on appeal, and it'll be interesting to see how it plays out. But I think the basic standard is simply, you are supposed to comply with a subpoena, and you intentionally fail to comply. That's it. Now, if the subpoena was lost in the mail and you never got it, and then you never had the intent to not respond to it, okay, that's not a bad defense, right? Because you didn't have the intent to refuse to comply. Steve Bannon can't make that argument. He got the subpoena. He knew exactly what was expected of him, and he chose not to comply at all. And he made this argument about executive privilege and advice of counsel. So that's the standard. Now, if they want to have a willfulness layer in there, that he had to know what he did was wrong, good luck on appeal. I'll be curious to read the filings, but I'm skeptical it'll work.
So what do you think, Joseph, is the time frame here? Based on what we heard the attorneys say and Steve Bannon say, obviously they're planning to fight this. Sentencing is scheduled for October. So what would you expect to see happen here in the coming months?
I expect the sentencing might get pushed a few times in order for the appeal to run its course. Typically, that judges don't like to send someone to jail if an appeal is pending, even if the appeal may be a long shot. So I think that the sentencing will get pushed to sometime next year, but eventually Steve Bannon will probably spend a month or two in jail. That's probably what's going to happen.
All right, if you could stand by for us, we're going to go to CBS News senior investigative correspondent Catherine Herridge, who's joining us now from Washington. Catherine, can you talk to us about this decision made to go after and go ahead with these charges and this trial for Steve Bannon, knowing that they would essentially lose their leverage to compel him to testify by going through with this case?
This is one of the really difficult sort of calculations that has to be made by a committee and then also by the Justice Department. In terms of the January 6th committee, they had to balance the value and the necessity of the individual's deposition and then also their records versus taking a position that they couldn't be allowed to refuse cooperation and that they would be referred to the Justice Department. I would argue in Steve Bannon's case, they made a decision that there was information that they wanted to get from Bannon, but so much of what's valuable about Bannon's testimony and what he knows is really already in the public square. I mean, he's someone who is out there talking. We saw in the January 6th hearings how much media and material there was about Bannon and his insight and his intent and his motivation leading up to January 6th. So it does appear to me that there was a decision by the January 6th committee that they probably could do without his testimony. They had enough independent information on their own and that they would send a signal with Steve Bannon. For the Justice Department, they have to make a decision as to whether, if they bring this case, can they win? These are not the kind of cases that they feel that they want to go into that courthouse with any sense that they could lose this trial and maybe even lose it on appeal. So that's sort of the first point. The second is it sends a message to other people who are facing contempt charges. President Trump's former trade advisor, Peter Navarro, is also facing contempt of Congress. It's a very similar situation to Steve Bannon. He refused to sit for a deposition. He refused to provide records. So this really is sending a signal to him about what may be held in the future. And I say that because leading up to this point, the case that everyone pointed to was that of the former chief of staff, Mark Meadows. And Mark Meadows took what I would say was a clever and hybrid approach, and that he partially cooperated with the January 6th committee. He provided some records, he provided text messages, but he did not sit for a deposition. And that it made it a much harder argument that he was in contempt of Congress, that he failed to comply in any way with the subpoena. And that's where kind of the daylight, I think, is with the Steve Bannon case. He was very all or nothing. He was very confrontational. He refused to comply. And this is how he landed where he is today.
Catherine, I'm not sure if you can shed any light for our viewers on this idea that Steve Bannon was a presence at this meeting at the Willard Hotel in early 2021 in a room that was sort of dubbed the quote-unquote war room, where there was allegedly some organizing and planning and discussion that was happening, something that the January 6th committee was interested in hearing more about. Can you tell us a bit more about what we understand may have taken place there?
What the January 6th committee has been trying to lay out is any kind of connective tissue between the rioters, especially the seditious conspiracy cases, the Oath Keepers and the Proud Boys, and people in the White House are failing that people who were in President Trump's, closest inner circle. I don't want to speculate about what happened at that meeting, but it's been an area of considerable interest for the January 6th committee, as well as other meetings leading up to the violence at the Capitol. Bannon was someone who had a lot of inside information. But again, my calculation, my assessment is the committee decided that they had enough independent information about Bannon, his intent, what he knew leading up to January 6th, especially from his radio show, that they probably didn't need to compel the testimony. They could refer him to the Justice Department on this contempt of Congress charge.
And Keir Dougal, you're still with us on the phone. Keir, I'm going to ask you the same question we asked Joseph a moment ago about what we heard from Steve Bannon as well as his defense attorney about the avenues for appeal. We were talking about that a moment ago. What's your assessment of what we heard with respect to the legal arguments put forward by Bannon and his team? Do they seem to have a strong case in your view?
And how likely do you think it is that he'll get the maximum sentence, a smaller sentence? Where do you think this is going to fall based on those arguments we've heard?
Yeah, so I'm not particularly impressed with the arguments that I heard outside the courtroom by Mr. Bannon's attorneys. It seems to me to be a pretty run-of-the-mill complaints about the process. The process that the Justice Department goes through and the process of putting evidence in that's admissible, supervised by a trial judge. In front of a jury, that is a very finely tuned process, and one that doesn't very often lead to errors at trial. We have a very complicated appellate process at potentially 2 levels to correct any of those errors, but after a full-blown trial, errors of the type that I think Mr. Bannon's attorneys are complaining about are rare. I would not hold out a lot of hope. And on the question about whether he will get the minimum or the maximum sentence, for anyone, let's be real about this. For anybody to spend even 30 days in jail is a long time. It is very disruptive. For Mr. Bannon, if his conviction is upheld on appeal, he will be infamous now in the history of the end of the Trump presidency and the January 6th committee hearings and all of these things that are occupying our grave concern right now. He will be infamous as someone who has been convicted for contempt of Congress in those proceedings, assuming that his conviction is upheld. So the reputational hit that he takes because of this, I think, is probably more important than perhaps the time in jail. But even 30 days in jail is a lot of time, and of course it could be more.
We've been talking to CBS News legal contributor Keir Dougal. We've also had Joseph Moreno and CBS's own Catherine Herridge. We're going to take a quick break, and we'll be back in a little bit with more news.
You ready? A generation of kids opens up on CBS Reports.
I just want to be like a regular kid.
Their world, their struggles, their voices.
What if I was white?
A lot of people like to call names and make you feel ashamed for being proud of who you are.
Now streaming Gender.
I did not realize that you could change your gender.
Realizing how you feel.
You can be a boy, sometimes you feel like a girl, sometimes you feel like both.
Redefining who you are.
Identify as trans.
Gender fluid.
Non-binary and queer.
Is the idea of gender a thing of the past?
And to be yourself, always, no matter what anyone says, I love you.
Are the kids all right? Gender. Now streaming on the free CBS News app.
I'm Nora O'Donnell in our nation's capital. We're here at the White House with the President of the United States.
Thanks for having me. I appreciate it.
We've never done an interview like this before.
That's correct.
Tonight, a congressional investigation sparked by reporting from CBS News. What's your message to consumers?
They need help now. Tell him I feel it.
The CBS Evening News with Nora O'Donnell from Washington, D.C. on CBS and streaming on Paramount Plus.
We will witness yet another moment in history.
Want to go someplace new? Yeah, you do.
See something new.
Learn something new.
Meet someone new. Nate B in the house.
There's always something new under the sun.
CBS Mornings, weekdays.
When weather is about to get extreme.
We're talking about hail, we're talking about tornadoes, damaging wind.
Every second counts.
Let's now take a look at what that really means to you.
That's why CBS News and the Weather Channel have come together to bring you virtual weather technology so advanced, so real.
We can show you what it's going to look like when the storms come through.
You'll see what will happen, where it will happen, before it does. Feel the forecast on CBS News. Time to get prepared.
People from every corner of America facing challenges.
Everyone is just looking for some type of connection.
Just raise your hand and say, hey, I'd like to help.
Coming together to find solutions.
We are going to do something about it.
Their stories are our stories.
Welcome to Eye on America.
Stream now on the free CBS News app.
CBS News Sunday Morning with Jane Pauley on CBS.
We have an inspiring story that started with a strange act of kindness.
Yeah. We found it.
You're kidding me!
We got it.
We share stories that lift you up and brighten your day.
The Uplift. Stream on the free CBS News app.
Stories that inform, inspire, and brighten your day.
I've been waiting patiently for something like this.
Make every day a little more like Sunday morning.
Here comes the sun.
Stream on the free CBS News app Tuesday mornings.
A new study has found that more than half of metropolitan regions in the U.S. were undersupplied with homes in 2019.
This has led to home prices surging and consequentially exacerbating both racial and income inequality. An analysis from housing policy group Up for Growth determined the U.S. was short approximately 3.8 million homes to meet its housing needs 3 years ago. This is more than double the number from 2012. The housing shortage has also spread to dozens of other cities since then.
CBS News Money Watch reporter Amy Peakey joins us now. She wrote an